Hello, I'm Locke Meredith, and I'd like to invite you to join me on the next Legal Lines. We're fortunate to have on the show Judge Wilson Fields. He's a judge on the 19th Judicial District Court. He's going to talk to us about his experience, first of all, as a city councilman, then as a state senator, as a trial court judge, and also he is running for the First Circuit Court of Appeals. He's going to talk to us about what he did as a trial judge handling criminal matters, what he's doing now handling the civil matters. So join us on the next Legal Lines with Judge Wilson Fields. Welcome to Legal Lines. I'm Locke Meredith, and I'm very pleased to have on the show today Judge Wilson Fields. He is a judge on the 19th Judicial District Court. Judge, thanks again for being on the show. It's good to see you again.
Thanks.
Tell the folks, I know we've done this before, but tell the folks a little bit about yourself, a little background history. Tell us about your family.
All right, I'm married to Shaprika Baptiste. We have two sons, Wilson, Eric, and Wesley Earl. They're 8 years old and 6 years old.
Keeping you running, huh?
Absolutely, they're a handful. They love sports, and I coach them in all their sports, so that's fun. Grew up in South Baton Rouge. From South Baton Rouge, moved to the Fairfields area where I went to high school at Capitol High School, and from there to Southern University, and then Southern University Law Center.
Tell the folks about your family, because you have a very interesting family history in terms of being the youngest of 10 kids.
Yes, it's 10 of us. I'm the youngest. It's 6 boys and 4 girls. We grew up in South Baton Rouge in what most folks would call a shotgun house. You throw a rock in the front door and it hit the back. My father passed when my mom was 3 months pregnant with me, so I didn't have the opportunity to meet my father, get out and play ball like all kids would love to do. But Mama instilled in all of us just continue to work hard, and as long as you put God first, everything would turn out all right.
And so I understand that big old family of yours kind of kicked in there, and everybody supports each other.
Absolutely, absolutely. We're a very close-knit family. We gather often and make sure that everyone is happy and taken care of, and make sure Mama is happy. And she makes sure that all of us look out for one another, and that's the beauty of a large family.
And in preparing for the show today, I was doing some research, and it's amazing what you've done and what you did at a young age, because you were, as you mentioned, you graduated from Capitol and got a degree in business management at Southern.
Yes.
Then attended Southern Law School, and then got a master's from Tulane.
Yes.
In law. But during that period, while you were a second-year law school student, you ran for the Metro Council for Baton Rouge.
Yes, I guess I had that in my blood. One of my older brother, Cleo, was in the state senate at the time, and he was getting ready to run for Congress. And I just felt the need to be able to offer my service to the public in terms of the Metro Council. I saw the Metro Council as a way of giving back to the community, and especially a community has given so much to me. So I just want to offer my service. Well,
and even when you were in Southern getting your undergraduate degree, as I understand it, you were president of the student body.
Yes, I was the Student Government Association president, and that also kind of, I guess, propelled me to want to do more. Because when you represent over 10,000 students at Southern University, it gives you an opportunity to really see how you can benefit individuals by service. And so after I left Southern University undergrad and got into the law school, I felt the need once again to try to now take my experience and move it more to the community and serving the community.
And when you were on the Metro Council, I was reading that very quickly you were promoted or chosen as the chairman of very significant committees.
Yes, yes. My colleagues, and I thank my colleagues for that, it gave me an opportunity to serve as the chairman of the Capital Improvements Committee, and that committee dealt with all our capital outlay projects for the city, and I thought that was very important because the district that I represented, we were trying to make sure that we fix all the different potholes that we found in the community and also do some capital outlay projects, whereas we were trying to we had just completed building the office where I was at, the Delmont Service Center, and now that center has extended, I think, into 2 or 3 different phases since we've left. So,
and you were actually the youngest Metro Council member in the history of the council.
Yes.
Age 23, right?
Yes, I was 23 when I served on the council, and I enjoyed it. Being 23, some folks thought maybe you weren't quite ready, but my colleagues assured me that I was ready, especially by allowing me to serve as chairman of some of the committees.
More than talk if they put you in those positions.
Absolutely.
All right, and then you ran for the state senate, the Louisiana State Senate, and you won.
Yes, sir.
Again, at that time, you were the youngest senator that was practicing at that time or serving.
Yeah, I was the youngest senator in the longest legislator in the Senate and the House at that time. My district covered some 7 parishes. It was outside of East Baton Rouge. I had East and West Feliciana, St. Helena, Tangible Hole, and Point Capee parishes that we covered. So that was a great experience during that time.
And how long, as I recall, you were elected and then ran again unopposed?
I served the first term of the Senate for 4 years. My second term, I was opposed. We won in the first primary, and I served 2 years of that term before we were elected to the district court bench. So I served 6 years total.
Explain to the folks, Judge, what motivated you to run for the judiciary? Because prior to that, you'd been basically held executive positions as the president of the student government and as chairman of the city council, and were in the legislative process on the council and the state senate. So what motivated you to move into the judiciary?
Well, to move into the judiciary at that particular time, I was an adjunct professor at Southern University Law Center. So I was teaching the law, I was practicing law, and as a state legislator, I was making law. And so I thought it would be, at that time...
Kind of fun to interpret it, huh?
Right, time for me to go and interpret the law. So that's why I ran for the bench, because I felt like the experience that I had would have made me a better judge in terms of the different areas that I've already been in.
And in your private practice, as I understand it, you did a kind of a general civil practice, maybe some personal injury type of action, but also you were focused on public utilities.
Yes, that's where I went to Tulane to get my LLM, so I can try to broaden my horizon and do something a little bit different than just criminal law and the plaintiff law from the standpoint of personal injury. So I wanted to broaden my horizon and do some public utilities, because I felt like that was an area that was kind of untouched by a lot of folks.
And when you ran for the 19th Judicial District, I think it was O, you were the first judge for that district. Explain to the folks how that happened.
Well, the legislature at the time created another judicial seat for the 19th JDC because of the growing needs.
Huge caseload, isn't it?
Right, of East Baton Rouge Parish. So I was the first one to serve in that. It was 5 of us that ran at the time. We were fortunate enough and blessed to have won that race in the first primary. So we only had 1 year on that term, and then my second term was a full 6-year term. We ran unopposed, and now I'm in my second full term, and we ran unopposed on that one as well.
So 3 times.
Yes.
Been elected to that judicial district.
Yes.
Judgeship. Let's explain to the folks, as a trial judge, what you did. As I understand it, you handled initially just criminal cases, and then both criminal and civil, and now focused on civil.
Yes. When you first come to the 19th JDC, the judges amongst ourselves have decided that you first start off with just a criminal caseload, and then from there you start doing civil if you wish to go up to civil. When I got there, I thought it would be appropriate for me to do both criminal and civil simultaneously.
So you were really the only judge that did both of them at the same time.
Absolutely.
All right, let's continue this on the next segment. I'm Locke Meredith with Legal Lines and Judge Wilson Fields. We'll be right back. Welcome back to Legal Lines. I'm Locke Meredith, and again, pleased to have on the show today Judge Wilson Fields. He's a Judge Division O for the 19th Judicial District Court. Judge, again, thanks for being with us.
Thank you.
You talked about, as judge, that you've handled both criminal and civil type cases. Explain to the folks the difference between a criminal case and a civil case.
Well, in a criminal case, I guess the easy way to explain it is when an individual is charged of committing a crime. Be it theft, armed robbery, or murder, that's on the criminal side. And on the civil side, most folks recognize civil cases by car accidents. Someone is suing for some personal injury to themselves, would be on the civil side. And you have other cases on the civil side, but most folks relate civil sides to car accident cases and personal injury.
And another distinction, I guess, would be the fact that in the criminal matter, it's the state representing, I guess, the whole population that is the plaintiff, so to speak, or the complainant that is, if you want to describe it this way, suing the defendant, the criminal, who's been arrested. And then in the civil matter, it's a private individual or corporation against a private individual or corporation.
Right, absolutely.
Describe to the folks how the criminal process works. I'm not sure many folks really understand it. How does, I guess the DA gets the case, or the person's arrested, and take it from there.
Well, let's say a person is arrested for theft. The law enforcement officer go out and arrest that individual, take him to parish prison, and then write up the affidavit of probable cause. And then the district attorney's office will look at that and decide what they're going to charge that individual with, be it they're going to charge him with theft, armed robbery, or whatever the case may be. And once the district attorney's office actually bring formal charges against the individual, then it comes to the court for us to set it on our docket for the person to be arraigned, for them to plead guilty or not guilty.
That's what happens at the arraignment?
That's what happened at arraignment. Then after an arraignment, then that's when we were looking at the trial phase.
Judge, do you ever have people plead guilty at arraignment?
Yes.
Okay.
Yes. Sometimes you have individuals plead guilty, and then you also look at the different kind of crimes. You got a misdemeanor and you got a felony. You find most individuals plead guilty at arraignment on misdemeanors.
So is
felonies.
Is it a negotiated thing where the district attorney says if you plead guilty, we'll lower the charges or recommend a certain type of sentence or something like that, and that's the reason they plead guilty?
I can't actually say that's the reason why they plead guilty. Sometimes they decide to plead guilty because the charges have been lowered from a felony to a misdemeanor. A lot of times it's by advice of their counsel in terms of why they ought to plead guilty or take the matter to trial. If there's an agreement between the state, being the district attorney, and the defendant and their attorney, then they'll bring that agreement to the court, and we will say, yes, we agree with it or don't agree with it.
So you're not bound by that proposal submitted by the district attorney's office?
Absolutely not. Absolutely not. And sometimes when the agreement comes to the court, if we don't feel, we being the judges, do not feel that the sentence is appropriate for that particular crime, then we can say, no, we're not going to accept that. But most part, once the attorney and the district and the private attorney has gotten together and come up with an agreement, long as it doesn't violate any statute or constitution, then most of the time it's fine with the court.
And explain to the folks the difference between a misdemeanor, the penalty, I guess, for a misdemeanor versus a felony.
All right, let's just use theft, for instance. You go into Walmart and you're charged with theft. If that theft is under $300, then that's going to be a misdemeanor.
Okay.
If it's $300 to $500, it's called a relative felony. It's still not a full felony, but it's still above $300. But anything that's valued more than $500 is a felony, and the time that you can get in jail is different. On a misdemeanor, you can only serve up to 6 months. On a felony is anywhere from 6 months up into whatever that particular crime calls for.
What about the relative felony?
Relative felony, you're still looking at basically a 6-month sentence. It's just not, the penalty can be a little higher in terms of the amount of money you have to pay back.
And so in addition to the potential jail time, there's also fines that
There's
are...
also fines. On a misdemeanor, it's up to $500. And on a felony, like I said, it depends on what that particular crime is. The statute has different penalties for different type of felonies.
I know in the federal court system, there are guidelines, sentencing guidelines that the federal courts, for a long time, they just had to flat out do what it said. It seems like maybe they have a little more discretion now. Do the state court judges have guidelines which they have to follow, or is it completely within your discretion?
No, we have discretion. There are some cases that, say for instance, a second-degree murder, we do not have any discretion. If that person is found guilty of a second-degree murder, then the statute already provides for that sentence, which is automatic life imprisonment. but most statutes provide a range that we can sentence an individual. So that's where our discretion comes in, as long as we stay within that range based on what we feel the evidence has shown.
And in your experience, Judge, handling the criminal matters, did you find that there was a lot of return criminals? Did the system work? Was there ways, sentencing processes that were better than others? What was your experience?
Well, my experience is that you do find some repeat offenders. However, for the most part, I think the system is working. We always can do better, but you do find those individuals, no matter what type of sentence you give them some jail time, they get out of jail and they tend to go back and commit another crime. And then that's where another part of the criminal code kicks in, where we call habitual offender. And if a person is deemed to be a habitual offender, then his or her time can actually be double the maximum amount of time that they have to serve.
So folks who are maybe first-time offense or first-time crime, that's recognized, and they're not going to get the same type of sentences as somebody who does it regularly.
Depends. Depends on what type of crime that is, but for the most part, you're correct. A first-time offender, we have a statute which is 894 on a misdemeanor, meaning that you put them on probation for a certain period of time, and if they do not do any other crimes in that period, then their record can be wiped clean. And on a felony, it's an 893. So for those individuals who are first-time offender, just got caught up in something that they shouldn't have,
made a bad decision,
then the system allows them to go through the system, and hopefully they won't come back again. But for those individuals that continue to do crimes, we have, as I stated, the habitual offender, which gives them additional time that they have to serve.
And is the jury system used all the time in the criminal court, or is it an option to go with the judge?
No, on a misdemeanor, you don't have a jury trial. The Constitution doesn't afford you a right to a jury trial. But on all felonies, you have a constitutional right to a jury. And that depends on the defendant. If he or she wants a jury, they can opt out not to have a jury trial and let us, the judges, alone try the case. But for the most part, they choose a jury trial.
And I assume if it's chosen to go with the judge deciding the matter, it's much quicker than if a jury system is involved.
I can say it's much quicker from the standpoint you don't have to use the day or day and a half it takes to pick a jury. And if they want the judge to try the case along, then it can move along a little bit quicker, because you don't have to take the different kind of breaks you have to take to make sure that your jurors are focused.
And of course, the judge knows the law, whereas the jury's got to be educated on it.
Yes.
Okay. Let's continue this on the next segment. This is Locke Meredith with Judge Wilson Fields. We'll be right back. Welcome back to Legal Lines. I'm Locke Meredith, and we're again very pleased to have on the show today Judge Wilson Fields. He's a judge on the 19th Judicial District Court. Judge, we talked about your duties and responsibilities in the process at the trial court level when you're dealing with crimes or the criminal docket. Let's talk about your experience handling civil matters at the trial court level. Tell the folks how that works.
Well, it works from the standpoint of, say for instance, if someone gets in an accident, I'm just going to use the personal injury most folks identify. Someone gets in an accident, and if he or she feels that they were hurt in that accident, they seek an attorney, and once they go through all their medical process, they file suit. Long as it's within that 1 year, they file suit, and once the suit is filed in district court, it get allotted to one of the judges that's handling civil cases.
And the process, the administration of cases, as I understand it, you have been chief judge for the 19th Judicial District Court. And you were talking about the allotment of cases. What are the chief judge's responsibilities and duties?
The chief judge's responsibility and duty is to make sure the court is run efficiently, and making sure that all the judges are doing their very best in terms of moving their dockets along. And if a particular judge is going to be out for any particular reason, they have to let the chief judge know, so we can make sure we get an ad hoc judge to continue that docket.
Is there a process which tries to make sure each judge is handling roughly the same number of cases or files?
Yes, actually that goes through the clerk of court's office. When when someone come file a lawsuit, depending on what type of suit that is, the clerk has a system to make sure that each one of us get the same number of cases as best as they can, so everybody can have the same amount of cases that's allotted to their division.
And how are decisions made? Because it sounds like the chief judge is kind of like the, say, governor or the president of the judicial branch at that time, that district. Is it a kind of everybody votes on how they want to do it and the majority implements, or is it the chief judge decides? How does that work?
Well, that depends on that chief judge. We have full judges meeting every month, and what I did and what all of us do is at that full judges meeting we bring various issues to all the members and then we vote on them. And the chief judge role, in my opinion, is mainly to bring the issues before the body and make sure that everybody understands the process that we're operating under. And of course, if there's a tie, then the chief judge breaks the tie.
I see. Excellent. All right, well, so on the criminal side, then the suit is filed because it's allotted by the process of the clerk. And
the civil side.
Right, the civil side. Mm-hmm. And what is the role of the judge from that point forward?
The role of the judge is lawyer driven, because once you file a lawsuit, we as judges do not go and grab your lawsuit and put it on our docket. The lawyer will have to ask for either a motion date or a status conference to get a trial date. And when they ask for a status conference, they come in and we give them various dates that they have to follow and also give them a trial date. And then once that matter comes to trial, then you, once again, before the judge and the jury, if it's a jury trial.
So up until the trial, the judge's involvement is mainly kind of, I guess, if the parties start fighting amongst themselves, he's got to get involved to handle. And then there's called pretrial motions. Explain to the folks what those are.
Pretrial motions, every Monday, for instance, in my court, every Monday morning, we have what we call rule day. And on any given rule day, I may have 30 to 40 rules set. And someone may file a motion for summary judgment, meaning that they feel that there's no genuine issue or material fact on that particular case and try to get the case dismissed. And we hear those every Monday. And depending on what we rule, that case may be dismissed or it may continue on to trial. And there are other motions they may file, exceptions of prescription and lack of venue or subject matter jurisdiction or no cause of action. So we have to make rulings on those every Monday on different kind of cases, and that determines whether or not your case is going to continue to move forward or whether or not it's going to be dismissed or some settlement may happen at that point.
So it helps make the process more efficient.
Absolutely.
If a case shouldn't be going to trial, then it gets rid of the case before it gets to the trial level, and it narrows the issues down via various motions so that when it does go to trial, then only the issues that are important to the matter to be decided are, I guess, contemplated by the judge.
Absolutely. And it also helps the process from the standpoint, especially if you have a jury trial, then the jurors do not have to worry themselves with all the other different type of things that may have happened in the case if we didn't have those motion dates set previously.
Because, Judge, when a jury is deciding a case, they're actually the judge.
Absolutely.
And explain that to the folks.
Like I tell all the jurors, you are acting in the same function that I'm acting in. As a matter of fact, when we have a jury trial, the jurors are the judge, and I'm only there to referee at that point, because all the issues are going to go before the jury for them to decide what they feel was proven or not proven. And whatever they decide is fine with me. And because I don't want any juror to second guess themselves by thinking, well, I don't think the judge would agree with this, or I don't think the lawyers would agree with this. You are the judge. You have to determine the facts and the evidence for yourself, and whatever decision you make, that's fine with us.
And we were discussing before the show that steps have been taken with the construction of the new building that are actually going to make the experience of serving as a juror much more pleasant, frankly.
Absolutely. Right now the process is the jurors come on Monday morning and they meet in the old state capitol, and then from the old state capitol they'll go to the library, which is across the street, and then from the library they finally come to the courthouse, which that process is a little tedious for most jurors. With the new courthouse, we're going to have one room where all the jurors come that morning and they don't ever have to leave out the building. So as soon as they finish the orientation, they can come straight up to one of the courtrooms to start their jury service. So I think that's going to make it a lot better.
The Judge, you're running for the First Circuit Court of Appeals. Explain to the folks what's motivating you to do that and how your experience is translating into running for that position.
Well, after serving 8.5 years on the district bench and handling both criminal and civil cases, I feel that it gives me a unique experience to go to the First Circuit, because what happens at the First Circuit, the only cases go to the First Circuit are those cases that are appealed from the district court level. And those are cases that I, as a judge, or one of my colleagues have ruled on, and so it goes up to the First Circuit. And who's best to grade papers than someone who has already been there taking the test? So I think by me being on the First Circuit gives me a better and a unique opportunity to know what actually takes place on the district court level, to be able to better understand it when I get to the First Circuit.
Explain to the folks the difference between being a trial judge in an appellate court, because at the appellate court there is no trial. Explain that to the folks.
At the appellate court there's no trial. All the appellate court is doing is reviewing the record of the district court and hearing the arguments from the attorneys based on what they feel the district court erred in. And also you do not have the litigants there. You do not have the actual victims or folks who say they are victims at the appellate court. So you don't put on any witnesses, you do not have a jury. Only thing you're doing is listen to the arguments of the lawyers. And you as a judge, you're not serving alone. You're normally serving in a 3-judge panel, meaning 3 judges they are sitting listening to the arguments and making a decision. On a district court, you only have 1 judge, and that judge is listening to the arguments, the witnesses that are being put on, and making a decision.
Judge, thank you so much for being on the show. We appreciate it very much. This is Locke Meredith with Legal Lines. Been with Judge Wilson Fields. Thank you for being with us today.